Clarence Earl Gideon was charged with breaking and entering into Panama City, Florida pool hall and stealing money from the hall's vending machine. At trial, Gideon could not afford a lawyer himself, and thus requested the Florida State Court an attorney be appointed to represent him. However, he was told by the judge that Florida only provided attorneys to indigent defendants charged with crimes that might result in a death penalty if they were found guilty. After he was sentenced to 5 years in prison, Gideon filed a habeas corpus petition, or petition for release from unjust imprisonment, to the Florida Supreme Court, claiming that his conviction was unconstitutional because he lacked a defense attorney at trial. After the Florida Supreme Court denied his petition, Gideon appealed to the U.S. Supreme Court by submitting a petition for a writ of certiorari for the Supreme Court to review the order and judgment of the lower Florida State Court, denying his petition for a writ of habeas corpus. So, the big question is, does the Sixth Amendment's right to counsel in criminal cases extend to felony defendants in state courts? In the process of analyzing the case, the 4 law clerks of each Supreme Court justice began to research legal issues and assist with the preparation of opinions and screen Gideon's petition for a writ of certiorari. During the process, 23 state attorneys general, led by Walter F. Mondale and Edward McCormack, submitted an amicus curiae brief on the side of Gideon, urging the Supreme Court to recognize indigent defendants' Sixth Amendment right to appointed counsel in felony cases. The Solicitor General, Archibald Cox, then proceeds to file the amicus curiae brief and approves the case to be reviewed by the Supreme Court. The oral argument between attorneys for both sides began on January 15, 1963. Afterwards, a conference was held between the Supreme Court justices to discuss about their decision. On March 18, 1963, Justice Hugo L. Black and the rest of the court held that it was consistent with the Constitution to require state courts to appoint attorneys for defendants who could not afford to retain counsel in their own. The court reasoned that the Sixth Amendment's guarantee of counsel is a fundamental and essential right made obligatory upon the states by the 14th Amendment. The Sixth Amendment guarantees the accused the right to the assistance of counsel in all criminal prosecutions and requires courts to provide counsel for defendants unable to hire counsel unless the right was completely and intelligently waived.
Thank you for watching.